Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from PALGRAVE MACMILLAN, and it's quite an important book. I think it'll be very helpful both for practicing lawyers and also advisors, of course, and also lay people, because it's dealing with a very difficult area and it's a controversial area as well. The title of the book is Employment Screening and Non-Conviction Information, a Human Rights Perspective. It's been written by two people, Thomas and Kevin Bennett. Now, the point of this book is concerning the information that is available and given or obtained by people who are seeking to get a job. Now, we're just coming to a point, I'm reviewing this in the middle of 2020, we've got a point at the moment where we have a massive amount of unemployment caused by the pandemic, and therefore this area of law is going to be important because we're talking about the balance between what information should be available and where the human rights perspective comes in. Now, I've given the title of this review, Where the Malicious Succeed, a realistic assessment of non-conviction information disclosure. The reason I say that will become apparent, but it will be, of course, many people will be aware that there's a lot of nasty people out there who make these unfounded remarks and comments about people which have no substance. And one of the problems about non-conviction information is where there's a suspicion, but there's been no conviction. There may have been a trial, but there's been no conviction. And of course, the concept of someone walking free from court without a stain on his character, which I will repeat again later, is a bit of a joke in this day and age, because clearly there's a lot of information that's out there which can be obtained in order to make sure that if you're, for instance, an employer, making sure you've got the right person. And obviously a large amount of this information is in relation to public sector employment. Let's look at the book first of all. It's a short book. It's 150 pages. There's a hardback. There's the spine. You probably can't see much. You can hardly see anything on the back. That just tells us about little bit about the book and about the authors. The book itself, as I say, is not a long book. It's 150 pages. There's a very short index right at the back. It's by page numbering, but I think the index could do with expanding, as the book could. I like the bibliography. I thought the bibliography was really substantial. There's a lot of information. They've done a lot of detailed research. Then, of course, at the back you have some cases, and then after that you've got references to go with each of the chapters. And if I go to the front of the book, there's the front page there, and then the main front page. I did think the concept of a human rights perspective was useful as well. Then you've got the blurb about the book. It came out at the beginning of, in fact in 2019 I think it was published. I'll get some information later about that. There's a preface, which is quite a long one, talking about really how the book germinated. Then there's some references, and then of course you've got the basic content structure, the disclosure of criminal records to employers, the nature of non-conviction information, police disclosure on non-conviction information up to 2010, and then after 2010, mainly because of various reports and cases. Then the making of the decision to disclose, human rights and conclusions. And then you've got a useful little abbreviations section, which I did find very helpful, again, because there's quite a lot of information that is down to abbreviations, so you do need to know what some of these abbreviations stand for. Then you go right into the book itself. And there is some footnoting, of course, at the bottom, not too much, a little bit, and you'll find the references for each chapter at the end of each chapter. And as I say, there's a fairly substantial bibliography right at the back. I found it an interesting book, and one that I, from the point of view of practice, is quite important. Probably not quite so important for members of the bar, but I certainly think this is a book that people who are seeking a job might find useful to read, bearing in mind what the onus is in terms of what they have to do and what they have to disclose today, because clearly if they don't disclose certain things which become known later on, that can have an adverse effect. So what do I say? It's a great book. in my view, reviewing how non-disclosure information is used. And the two authors, Thomas and Kevin Bennett, both academics from Leeds and Sunderland, outline the development of the current systems of disclosure of both criminal records and non-disclosure information held by the police and given to employers. Now, non-disclosure information is where the problem is. It shows how the two systems of information run side by side, giving the subject matter a useful human rights perspective in what is about 150 pages. I think it's a book that will expand, clearly, because there's a lot more in this area, and probably a lot more is to come concerning this, certainly what is called the non-conviction information, because the publishers here offer, I think, the reader who will be a job applicant, quote, a critical overview of the policy frameworks underpinning the contemporary practices of non-conviction information disclosure during pre-employment screening. And of course that's the point, because many people will apply for hundreds of jobs and what quite often will have no idea why they haven't got anywhere, because no one ever tells them. But of course it's the screening process which is the problem. And again, as I've said before, unfortunately there are quite a large number of instances where people have made completely unfounded allegations about other people, and that can have a very detrimental effect. So what the authors do here is give a short, useful guide into this employment minefield, if you like, as the supposed right to silence continues to be eroded. In other words, there is no right to keep silent about something, you have to disclose it. And of course the authors question how a man and a woman can walk free from a criminal court as an innocent person, only to have all the court details of his or her acquittal passed to any potential employer as disclosure. Now that doesn't seem right, but of course you are going to get something else, and that is you are going to get the press and the internet covering cases. So therefore, even if there's an acquittal, all the information is out there, even though they try to change things sometimes, the media try to change things sometimes at a later stage with inferring, instead of referring to a man's surname, just the letter B or whatever it might be. You can see the problem, because actually the disclosure has already taken place by that time. So the damage effectively has been done because the information is in the public domain. And that again is an important point, because of the strength, the power, the sheer power of the internet as a data device. Now, the book explains the current policy, which means that no one leaves the court today without a stain on his or her character, which was the old phrase which I've referred to before, because the damage has already been done with the launch of the proceedings. And of course it's a charter to encourage those making more vindictive and unfounded allegations from benefiting in kind from the hurt inflicted on the innocent, even if proceedings are not started, but mere rumour persists. Now, again, that happens on a much larger scale than anybody would like to admit, because if there's any question of an issue, the screening process puts that particular application in the reject file, and you can see the problem. So the question really is, how much can the Human Rights Act and the human rights concepts, in terms, as they call it, perspective, assist? Well, what Thomas and Bennett do is they write that despite several million enhanced criminal background checks being performed each year, there's actually been little discussion of these issues within academic literature, and they're right about that, because it's not a comfortable area for quite a lot of people as well. But clearly there is this problem. There has been a political issue about disclosure over the years. I'm talking really now about certainly 45 years. I'm thinking back to the 70s, and the issues concerning convictions and stale convictions, and how long they should be kept and how long people should be allowed to know about them. But of course the whole idea that once you've paid your debt to the society or something, that the slate is clean, is a complete nonsense. But there we go. I do think this book would have been actually quite helpful to us some years ago when we did the bar exams, because again this sort of information is quite useful, but it's more, I think, to do with advising people, especially aggrieved applicants who've lost a job. And so, as I say, I think the book itself is something that will be very helpful for people looking for a job. Sadly, of course, the subject of non-conviction information, which is sometimes called police intelligence, has been with us for a very long time, because it's the beginning of the criminal process to detect crime successfully. So the balance has to be set, and I do see that. Unfortunately, this less well-known check is frequently offered alongside the criminal record check, notwithstanding the safety mechanism of a human rights safeguard, which barely exists actually for the hapless job seeker, who usually fails in the job search as a result. And as I've said, there may well be substantial grounds for concern, but there are a lot of malicious allegations out there as well. And what we're given here is a modern definition of what is interpreted as non-conviction information, for those who don't know what it is. And they explain it in some detail. But again, the question really would be, should this information be available at all? The answer is it's going to be available, and I don't think there's much you can do to stop it, because as I indicated, there are large numbers of databases in the media and on the internet where you can get the information today, just by Googling people's names, for instance. So what the authors do here is they present us with a clear and simple explanation of how this decision-making process of police disclosure to employers is made, and it should be read, I think, by all job seekers and certainly personnel employees and those concerned, because they obviously will be concerned about their reputation. They call them human rights operatives today, or whatever the term you want to use, but the people who are actually sifting through and screening, I think they should be aware of this, because I think sometimes they actually go way beyond what certainly what Parliament originally envisaged. And of course it may be that we need some tightening up of the rules. We may well get it, because we are going to have a very high level of unemployment now for some years because of the pandemic. In addition, of course, the book gives an extent to the practices which have been subjected to legal challenges within the UK. Costs a lot of money, of course. They're well covered, and it's an issue really of how public protection can be balanced against individual rights. The old story again, but I think it's important because there has to be a balance there. Let me conclude by saying that sadly it remains our view that public protection heavily outweighs the rights of the individual in this area. So the book is a must as guidance for the job seeker who might be adversely prejudiced by unproven and often malicious information, with defamation proceedings well outside the financial circumstances of almost everybody, because the malicious succeed, and that has been the problem now for generations. Unless you're very wealthy, your reputation can be seriously damaged, and there's nothing you can do about it. So thank you to Terry and Kevin for an excellent new book in what is a difficult area of human rights law. I thought it was a very useful book from my point of view, because clearly I hadn't actually thought as much about the whole issue of non-conviction information before, and I realised that in fact it can be used in the wrong way. The publication date of the hardback is given as at the 14th of September 2019, and let's just have a quick look at the book again. There it is there, and then there's a spine and then the back, and then just opening it in the middle, young people, criminal records and non-conviction information, looking specifically at them, because again the problem is if you're young you may make a couple of mistakes, and that can be you dealt with for the rest of your life if you're not careful. It says an area of particular concern has been that surrounding children and young people who acquire criminal records between the ages of 10 and 18 and also have police non-conviction information held against them. Again, you can see the damage that can do. So I think the book is extremely thoughtful. Then you've got guidance about how people will go about dealing with disclosure, because it really is. And then you've got the Serious Organised Crime and Police Act 2005, which is covered. But the issue, of course, as always, is about disclosure. What do you and do you not disclose? And that, of course, is always going to be a problem. Disclosure's been a problem for lawyers for a very long time. And of course the difficulty I have, and I'm sure many practitioners would agree with me on this, is that quite often it's what you haven't told me which is what I need to know, because that's probably what is going to come out and ruin the case if we're not careful. So you can see what the problem is in a more general point of the legal picture. Anyway, thank you very much to all concerned. This is an excellent book and I'm delighted to review it. Good luck. Bye-bye.